And thank you everyone for joining me this morning. Yes, so we are Kaye Rembaum, attorneys at law. I am here in our Palm Beach Gardens office, but we also have two other office locations, one in Tampa, one in Pompano Beach down in Broward County. And we also have offices available in Miami-Dade County by appointment. We are, 19 attorneys. A lot of us are board certified, and we do all of our collections and litigation in-house. And we do soup to nuts, condominium, HOAs, cooperative representation, contracts, amendments, full-blown governing document projects, violation letters, you name it, we do it on behalf of the association. So now that you're on the board, you need to be certified. So let me share my screen so that you will see PowerPoint presentation, and you will be receiving a copy of this at the end. As Jeff was mentioning before, you'll get the link to the materials. So why are you here? Sometimes I walk into a room and ask that myself. You will not have to retrace your steps. I will let you know. Pursuant to Florida law, within 90 days after being elected or appointed to the board, you have to become certified. There are two ways to do it. You submit a certificate of having satisfactorily completed an education program just like this. It can be done a year in advance or within that 90 days. Or you can certify in writing that you've read the governing documents, will work to uphold the governing documents to your best of your ability, and will faithfully discharge your fiduciary responsibilities to the association. We call this the Scout's Honor. There is a form available from the Division of Florida Timeshares, Florida Condominiums, Timeshares, and Mobile Homes, which we'll mention later on. A director who fails to timely be certified is temporarily suspended until they meet that certification requirement. The board can fill the vacancy for that temporary time. The certification does not have to be repeated so long as there's an uninterrupted tenure on the board. However, we do recommend that you come back every year. As Jeff was saying, it gets updated every year with the legislative changes. So sometimes a lot changes, sometimes only a few things, but there are changes every year. So we do recommend coming back to the class every year. That certificate that you'll get at the end, you need to give that to your secretary, whoever is the custodian for your official records. It has to be kept for at least 5 years after the election or appointment. Failure to have the certificate does not affect the validity of any board action. Just be sure that you do get certified, because as I stated before, it is an automatic suspension from the board. So the 2021 legislative session did have a bunch of changes to HOA law this year. There will be an indication on the slide with the double asterisk and some underline. I've also made it blue to be a little bit more clear because some other text would be underlined. So Chapter 720 is our operative chapter of the Florida statutes for homeowners associations. For condominiums, it's 718. I'm sure many people are familiar with that number. But for our HOAs, it's 720. It used to be a subsection of Chapter 617, which is our Florida Not-for-Profit Corporations Act, which almost all homeowners associations are not-for-profit corporations in the state of Florida. So there are some differences between HOAs and condominiums. Like Jeff said, this is the HOA class. If you're looking for the condo class, keep an eye out on the KBR website. We do have a calendar there so you can sign up. And if you're have your email with us, we'll be sending out email blasts. But there are some differences. There are a lot of similarities too, but be sure to become familiar with your particular subsect. So homeowners associations, they exist with or without their enabling legislation. They are creatures of common law, not of statute, which is how a condominium is developed. It's under 718. That's what creates the condominium, and 711 was its predecessor. The association owns common areas in its own name. This is very different than in a condominium, where the condominium association's owners have an undivided interest in the common elements of the association, the condominium. HOA board decides issues regarding material alterations unless there's some type of approval requirement in the governing documents. In a condominium association, there is that statutory 75% approval requirement unless something else is provided in the governing documents or the declaration. An HOA's declaration of covenants is not a title document. When you look at your deed, it's not going to refer, the legal description for your property doesn't refer back to the declaration of covenants. It refers to a lot number of a certain plat recorded in the plat book of the county, whatever plat book number that is, whatever page that is. Very different in a condominium association. The condominium declaration actually creates that title. So when you're looking at a deed for a condominium association unit, you are going to see the declaration referenced unit, declaration of condominium recorded, and the recording information for that declaration. So 720 is really for residential components, does not govern commercial components. And sometimes there will be reference in chapter 720 to other chapters like 718. And you will see that later on in the presentation, particularly when it comes to recall and election disputes, which the Division of Florida Condominiums, Timeshares, and Mobile Homes has jurisdiction over. So chapter 720, we know we have this statutory chapter that governs homeowners associations, but as I said before, it changes every year. So what version of this statute applies? Well, under general contract law, the substantive law in effect at the time that the contract is entered into, in this instance, the declaration is that contract, the law at that time gets incorporated into the document. Constitutional due process rights protect us from retroactive applications from laws that adversely affect or destroy a vested right, impose or create new obligations or duty in connection with the previous transaction, or impose new penalties. There are certain exceptions to this, one of them being the Kaufman type language. Now, Kaufman is a name pulled from a condominium case. Oftentimes, condominium decisions influence homeowners associations, and certainly it did in this instance. So Kaufman language is that as amended from time to time language. And when it's used with reference to chapter 720, it means that each year's legislative changes become automatically incorporated into the declaration. In the event the declaration does not have Kaufman type language, then we have to look at the particular provision that we're analyzing at the time. Does the legislation provide any guidance? It could have some language in the statute that says this is intended to clarify existing law. Well, if that's the case, then you will apply. If it's an issue of public policy, the legislation will also provide that, and the legislation will apply. If there is no type of guidance in the legislation, well, now we have to say, what type of change is it? Is it a substantive change or is it a procedural change? If it's procedural, well, the legislation is going to apply, notwithstanding no Kaufman language. If it's substantive, more likely than not, it's not going to apply. Procedural laws are the how-tos, how we get things done. And a lot of our procedural stuff for our associations, they're in the bylaws of the association. Substantive laws prescribe legal duties and rights. Once they become vested, due process prevents the legislature from retroactively abolishing or curtailing them. And here are some examples. Again, like I said, condominium law case law tends to have an influence on HOA law, which is why there is a reference here to a condominium case about different types of substantive rights. I mentioned before that Chapter 720 used to be a subset of Chapter 617, which is our Florida Not-for-Profit Corporations Act. The Florida Not-for-Profit Corporations Act will apply to the association, but to the extent that 720 has a provision for that issue, you're going to follow Chapter 720. And it's a general rule of law. You take the specific over the general. Here it's actually codified and was actually clarified by the 2021 Florida legislature that existing law, in the event of conflict, you're going to look to Chapter 720 over the provisions of Chapter 617. Now, I briefly mentioned that we have our bylaws and those provide our procedural how-tos. Well, we all know that we have our declaration, and that's kind of like our constitution. That's that contract. That's the big daddy when it comes to governing documents. Our articles of incorporation are it's the formative document for the association. That is what gets filed with the Division of Corporations up in Tallahassee to actually create the association. And our bylaws, again, are how-tos. What happens if there's a conflict between these documents? Sometimes there are conflicts. And oftentimes I feel like the conflict is either between the bylaws and the articles or the bylaws and the declaration, possibly having to do with eligibility to serve on the board, what have you. I always say the phrase, a little dabble do you, DAB. Your declaration controls over your articles control over your bylaws. And that is most often the case, except where Florida statute will direct you to a particular governing document. And usually that document is either going to refer to the bylaws or to the declaration. A little bit about transfer fees and estoppel certificates. Transfer fees are generally not favored by the law. However, there are certain exceptions, and having the fee in your declaration of covenants is one of those exceptions. This is why a homeowners association can have like an application fee, transfer fee, or a capital contribution working capital fee. Estoppel certificates. So this was added to the law maybe 2 or 3 years ago. Within 10 business days of receiving a written or electronic request for an estoppel certificate, the association has to issue the estoppel certificate. If you have a website, you need to designate a person or entity with a street or email address for receipt of the requests for an estoppel certificate. They have to be completed by a board member, authorized agent, or authorized representative of the association. And this can also be the manager and employee of the association's management company. Estoppel certificates have to be provided by hand delivery, regular mail, or email on the date of issuance of the estoppel certificate, and they have to be signed by an officer or authorized agent of the association. The statute sets forth a particular form of how this estoppel certificate must be issued. 3 different categories of information. There's some general information that's required: date of issuance, name of the owner, property designation, address, attorney's name if the account's in collections, name of the requesting party, the fee, and we'll talk more about the fee for the estoppel certificate coming up. Then there's the assessment information. How much are your regular general assessments? When are they due? What other assessments might be due? That would be in this particular section. And then they have an other information section. Importantly, this is the part where you get to put in whether or not there's a violation existing on the property. Like when I purchased my home, which is inside of an HOA, there was the mailbox was damaged. So they put that onto the estoppel certificate that the mailbox needed to be repaired. So when we purchased the property, we repaired it. Contact information for the insurance maintained by the association. And if the association is like a sub-association, just like mine is, you would also have to provide the information for the master association. So the fees are set by statute. A reasonable fee, if there is no delinquency, is $250. If there is delinquency, you can tack on an additional $150. If they ask for expedited, it has to be provided within 30 days, and you can charge an additional $100. In order to charge an estoppel fee, the authority to do so has to be established by a written resolution adopted by the board, or more often than not, in a written management, bookkeeping, or maintenance contract. If the association fails to deliver the estoppel certificate within that 10-day period, you cannot charge a fee for the preparation and delivery of the estoppel certificate. There is a way for the purchaser to obtain a reimbursement for the estoppel fee if there was no closing, and within that 30-day window, they make a request for the reimbursement. They're entitled to the refund within 30 days after receipt of the request. The refund is actually the obligation of the owner, so the association can get that money, the estoppel fee certificate, from the owner. Okay, so estoppel certificates delivered by hand delivery, they're good for 30 days. If it's by mail, it's 35 days. I guess they added in the extra 5 days to account for mailing delays. If additional information or mistake related to the estoppel certificate becomes known to the association within that effective period, it be the 30 days or the 35 days, an amended estoppel certificate can be delivered and becomes effective if a sale or refinancing of the parcel has not been completed during that effective period. That makes sense. A fee cannot be charged for an amended estoppel certificate, and it has to be delivered on the date of issuance, and it re-ups that 30 or 35 day effective period. This is important. This is why it's in red and in bold. An association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon the estoppel certificate and from the person's successor and assigns. So you want to be sure that the numbers reflected in the estoppel certificate are accurate. If not, it's the association's loss. Other requested information, lenders typically will make a request about any active or pending litigation that the association might be involved in. They can do so. The association can charge a fee. The fee cannot exceed $150 plus any reasonable cost of photocopying and any attorney's fees to supply that information. Okay, so a little bit of the procedure regarding members meeting. We have our annual members meeting. That has to be done, you guessed it, annually. And the election of directors has to be held at or in conjunction with the annual meeting or as provided in the association's governing documents. Every other meeting of the members other than the annual meeting is considered a special members meeting. When is it held? When called by the board or when at least 10% of the total voting interest of the association petition for holding the meeting, unless there's a different percentage provided in the governing documents. Oftentimes, if there is, it's going to be in your bylaws. Excuse me. If the bylaws don't provide for the giving of notice of membership meetings, the statute fills in the gaps. Then the association must mail, deliver, or electronically transmit notice to all members not less than 14 days before the meeting. You have to have evidence of having provided this notice by affidavit of the person who sends the notice. Has to be kept with the association's official records. Notice must be mailed or delivered to the address identified as the owner's mailing address in the official records of the association, or electronically transmitted if the owner has consented in writing to receive notice by electronic transmission. A lot of times our clients get a little bit confused between electronic transmission of notices and electronic voting. They're two very different things. We'll talk about online voting a little bit later, but as far as providing notices via email, you have to have the written consent of the owner in order to do so. All notices have to provide the date, time, and location of the meeting. Seems rather rudimentary. And the association may, by reasonable rule, adopt a procedure for conspicuously posting notice on the condominium, or excuse me, on the community property, or they can repeatedly broadcast the notice on a closed circuit cable television system. If you're broadcasting it, you have to broadcast it for enough time for someone to actually see it, read it, and understand it. As far as the agendas go, you're only required to have agendas for special membership meetings, unless your bylaws would require an agenda. Even though you don't have to have one pursuant to law for an annual members meeting, consider putting one in anyway. It helps to keep things orderly and lets your membership know what's going on. Special members meeting, again, have to have an agenda because the business conducted at a special members meeting is limited to the purposes described in the notice of the meeting. Members have the right to attend all membership meetings and the right to speak at any meeting with reference to all items open for discussion and all items included on the agenda. They can speak for at least 3 minutes. The association may adopt written reasonable rules governing the frequency, duration, and other manner of owner statements, and they have to be consistent with these particular items, including that 3-minute rule. The association absolutely should adopt some rules governing membership statements. A lot of times that tends to be what turns a meeting from what should have been 20 minutes to 2 hours. Membership meetings must be held at a location accessible to physically handicapped persons when it's requested by that person. Quorums and decisions pursuant to Florida statute, unless a lower number is provided in the bylaws. Remember, I was mentioning the little dabadilla, unless statute says, look at a particular document. Here's one of those instances. Unless a lower number is provided in the bylaws, 30% of the total voting interest of the association constitutes a quorum at a members meeting. So it's 30%. Very different than a condominium association. Condominium association is a majority. Excuse me. Unless otherwise required by law or the governing documents, decisions are made by a majority of a quorum. It's going to be by a majority of those members who are present in person or by proxy at the meeting at which a quorum has been attained. Unless otherwise provided in statute, and the statute talks about absentee balloting, which we'll talk about later, or in the governing documents, the members have the right to vote in person or by proxy. There are certain requirements to having a valid proxy. Has to be dated, has to include the date, time, and place of the meeting for which it's intended, and has to be signed by the authorized person who executed the proxy, or has to be signed by the authorized person. If your particular association has a voting member designation requirement, it would likely be that person or the member. A proxy is effective only for that particular meeting, has a life of 90 days. If you continue the meeting to a date, time, place certain, let's say you don't get a quorum or you don't get the particular vote that you want, you make a motion to continue the meeting, let's say next Tuesday at 7 p.m., same place, then the proxy would be good for that meeting as well. Proxies are revocable at any time by the person who executes them, and the proxy holder can appoint a substitute proxy if it's permitted on the proxy form. And a copy of original proxy can be used if it's a complete reproduction of that original proxy. There are two different types of proxies, a general proxy and a limited proxy. A general proxy not only counts that person as having been, that member as having been there for quorum purposes, but allows the proxy holder to vote however which way the proxy holder desires. Very different than a limited proxy, which also can be counted toward quorum, however, directs the proxy holder how to vote. In a condominium context, that's the only way that people can vote, members can vote by proxy, is by limited proxy. Okay, elections. So your elections have to be conducted in the manner set forth in your governing documents. We often find that associations have adopted the kind of condominium form of elections, which is all well and good, but a lot of times they use that without it actually being in conformity with the governing documents. So always look to your governing documents. If you want to change the manner of doing your elections, you need to be amending your governing documents, and you should contact your association's attorney to help you with that effort. That having been said, when we do them, we oftentimes are putting in like a pseudo condominium style where they're doing the pre-nomination double notice procedure, but not using the double envelope system. Still allowing the membership to vote by proxy. Let's see here. Directors are elected by a plurality of the votes cast by the eligible voters. Again, you're going to want to look at your governing documents to make sure it's not cumulative voting. More often than not, I don't think I've ever seen a cumulative voting requirement in any bylaws. A quorum of the members has to be established in order to hold the annual meeting and the election. All members are eligible to serve on the board unless otherwise disqualified. How were people disqualified? Well, if they're delinquent in the payment of any monetary obligation due to the association on the last date that that person can be nominated, they can't run for the board, they can't be listed on the ballot. If they've been convicted of a felony, either in this state or have been convicted of a crime in another state, which would be considered a felony in this state, that also counts towards this. They're not eligible to run for the board unless they've had their civil rights restored for at least 5 years. And a person who has pending criminal charges for felony theft or embezzlement offense involving the association's funds or property cannot be elected to the board. Unless the bylaws provide otherwise, their term that they're elected to is for a year. And on election day, usually a typical HOA election, you're going to have nominations from the floor. This may or may not be required by your governing documents, but if it's not, that's usually the gap filler that's provided by Florida statutes. Florida statute was amended maybe a few years ago to say that if the election process set forth in the governing documents allows candidates to be nominated in advance of the meeting, the association is not required to allow nominations at the meeting. So look at your governing documents. If there is a pre-nomination procedure, then you don't have to allow nominations from the floor unless it's required by your governing documents. And you're going to want to reach out to your association's attorney to provide you with a little of assistance as to how you can accomplish disposing of nominations from the floor when you have that pre-nomination procedure. An election is not required unless more candidates are nominated and the vacancies exist. If you have 5 vacancies and only 3 people nominate themselves to the board, you're not going to go through the balloting process. That makes sense. If an election is not required because there are either an equal number or fewer candidates, then vacancies exist. And if nominations from the floor are not required, then on the date of the annual meeting, regardless if there's a quorum or not, those candidates will be seated on the board. Members have the right to vote in person or by proxy unless otherwise provided in the governing documents. And remember, I was speaking about the absentee balloting statute. If the governing documents permit voting by absentee ballot, the ballot must be placed in a blank inner envelope without any identifying markings and mailed or delivered to the association with an outer envelope that has the name of the owner, designation of the lot, and the signature of the owner casting the ballots. All ballots and proxies are then tabulated at the annual meeting. Any challenge to the election has to be brought within 60 days of the election results being announced, and election disputes can be brought to either the division, that's the Division of Florida Condominiums, Timeshares, and Mobile Homes, it's done in accordance with the procedural rules adopted by the division, which are set forth in the Florida Administrative Code. Can also now file these disputes with a court of competent jurisdiction. That actually should have been in blue with underlined because that is new. Electronic voting. An association can use an online voting system for all owner votes if an owner provides written consent to online voting, which is valid until the owner opts out of online voting. But before the owner can opt in or opt out, the board has to adopt a resolution which requires a 14-day notice, similar to a membership meeting, in order to be adopted. Now, this resolution has to provide that owners will receive notice of the opportunity to vote through an online system, establish reasonable procedures and deadlines for owners to provide their written consent, and to also opt out of online voting. If an owner opts into online voting and they cast their vote via the online voting system, their vote is counted toward a quorum and toward the actual purposes of the vote. There are certain requirements that are prescribed by statute for online voting systems. They have to have a method to authenticate the owner's identity, be consistent with the association's election procedures, have a method to confirm at least 14 days before the meeting that the device is communicating with the system. And the system has to authenticate the owner's identity, authenticate the validity of each electronic vote, transmit a receipt, permanently separate identifying information from the vote, and secure and keep electronic votes accessible to election officials for recount, inspection, and review. Now that you have your new board, how do we select our officers? Generally, officers are selected by the board immediately following the election at what is called the organizational meeting of the board. Directors cannot vote by proxy or by secret ballot, except for when they're voting for officers, they can use a secret ballot. There's no prohibition in the law against changing officers midstream. You're put on there by the board as an officer. You can be taken off by the board as an officer. And here's a little trick question. Does the president vote? I think a lot of times people use Robert's Rules of Order improperly here. A president doesn't get a vote because officers don't get a vote. When you're voting as a board member and not an officer. So now that you're on the board, how do we conduct ourselves? The great power grab. Unless otherwise provided, the corporate powers of the association are exercised by the board. Therefore, the board is responsible for carrying out the association's duties unless there's a membership approval requirement. Unless delegated, no one board member should be acting on behalf of the board. And the board is generally responsible for the maintenance of the association property and has health, safety, and welfare powers. Again, directors cannot vote by proxy or by secret ballot. The only time they can use secret ballot is when they're electing officers. You can use email as a means of communication, but you can't cast a vote on any matter by email. Again, no board member should be acting unilaterally unless that power has been delegated to them or unless there's an emergency. And we'll talk more about emergency powers later. The officers and directors of the association have fiduciary responsibility to the owners. They have to act reasonably. That's using the reasonable business judgment rule. It's okay not to be right on occasion, but again, you need to be acting reasonably and using that reasonable business judgment and making decisions for the association. All board meeting notices have to include the date, time, and place of the meeting. You cannot levy an assessment at a board meeting unless the notice of the meeting includes a statement that assessments will be considered and the nature of the assessments. And the same meeting requirements for the board apply to only certain committees. Any committee, when a final decision will be made regarding the expenditure of the association's funds, and to any meetings of a committee that has the authority to approve or disapprove architectural decisions, be it called the Architectural Control Committee, be it called the Architectural Review Board, Architectural Review Committee, arose by any other name. If that's its function, their meetings need to be noticed. There are two different types of board meeting notices. Generally speaking, notices of all board meetings have to be conspicuously posted in the community for at least 48 hours in advance of the meeting, except in an emergency. Again, you're going to want to look at your bylaws to see if there are any other requirements in the bylaws. Unless the bylaws provide otherwise, written notice of any meeting at which special assessments or an amendment to a rule regarding parcel use will be considered. Those have to be noticed similar to a membership meeting, being mailed, delivered, or electronically transmitted to all owners and conspicuously posted on the community property not less than 14 days prior to the meeting. Again, if you want to use electronic transmission for notice, you have to have that written consent from the owner. So there is a new provision which allows board meeting notices to be posted on an app. If you're posting notice on the app, you have to be sending an email to the person alerting them that the notice is there. And that has to include a hyperlink to the website or to the app where the notice is posted. That's basically what this is saying here. Compensation. I know you guys are not in it for the money because you cannot directly receive any salary or compensation from the association for the performance of your duties as a director, officer, or committee member. And you can't in any other way benefit financially from your service on the board, except for in these limited circumstances, if you are participating in a financial benefit accruing to all or significant number of the members, reimbursement for out-of-pocket expenses, if they've been approved by the board, insurance proceeds, if there's any recovery for that, If there's any fee or compensation authorized in the governing documents by a vote of majority of the voting interests, majority of a quorum here, a developer or its representative serving as a director, officer, or committee member can be paid as an employee of the developer. Contracts between the association and a director. These are your conflict of interest provisions. If the association enters into a contract or other transaction with a director or a corporation in which their director has an interest or is also a director, the board has to comply with the following requirements. That contract has to be fully disclosed to the board and entered into the minutes of the board meeting at which the contract will be considered and voted upon, and has to be approved by 2/3 of the directors present. The contract has to be reasonable and fair to the association, and at the next regular or special members meeting, the contract has to be disclosed to the membership, and the contract can be canceled by a majority vote of the members present at the meeting. If it is canceled, the association's only liable for the reasonable value of goods and services received up till the time of cancellation. And if there's any liquidated damages clause or termination fee, that's not going to be applicable. Guilty until proven innocent. Director or officer charged by information or indictment with any felony, theft, or embezzlement offense involving association funds or property is removed from office. Recall, this might sound familiar because it is one of those things that will disqualify you from eligibility to run for the board. The vacancy is then filled by the board until the end of the suspension period or the end of the director's term. We mentioned the suspension period because if the charges are resolved without a finding of guilt or without the acceptance of a plea of guilty or nolo contendere, that means no contest, the director or officer must be reinstated for the remainder of the term. That's why that word suspension is there. A director or officer who has the charges pending, again, cannot be appointed or elected to serve on the board. So we call this the $25 rule. Sometimes it's referred to as the McDonald's rule, not to be derogatory to anyone who enjoys McDonald's. On behalf of themselves or immediate family, an officer, director, or manager cannot solicit, offer to accept, or accept any good or service of value for which consideration has not been provided from any person providing or proposing to provide goods or services to the association. There is an exception, a couple of exceptions. One would be food to be consumed at a business meeting with a value of less than $25 per individual. That's where that McDonald's name comes in. Or a service or good received in connection with trade fairs or education programs. If you've been to a trade fair and you've received one of our stress balls, you don't need to be squeezing it continuously because you will not be kicked off the board for having that stress ball. If the board finds that an officer or director has violated this subsection, the board has to immediately remove the officer or director from office, and the vacancy is then filled according to law until the end of the officer or director's term. For that vacancy that's created, it's then filled by the board unless the expiration of the term is unless the board seat is open by the expiration of the term. If it's by the expiration of the term, then that's going to be filled by election at the annual membership meeting. Any other vacancy gets filled by the board. There is just one little caveat when it comes to recalls, and we'll talk about recalls later. Even if the board constitutes less than a quorum, the board can fill those vacancies. Any vacancy filled by the board in this manner is for the remaining unexpired term of the seat being filled, unless otherwise provided in your bylaws. Members also have the right to attend all board meetings and the right to speak at board meetings with reference to all designated items. There are a couple of exceptions to these rights. Any meeting between the board and its attorney with respect to proposed or pending litigation where the contents of the discussion would otherwise be governed by the attorney-client privilege, and meetings held for the purpose of discussing personnel matters. Again, the association may and absolutely should adopt reasonable rules governing the frequency, duration, and other manner of member statements, including, for example, a sign-up sheet for members wishing to speak. Unlike the member's right to speak at membership meetings, there is no time frame that's provided for directors meetings, although you can reasonably adopt a rule that requires or that has that 3-minute threshold. An owner may tape record or videotape both board meetings and member meetings. The board can adopt reasonable rules. For example, having to set up the equipment before the meeting begins, or to not have equipment that creates disturbing lights or sounds. Board meetings must be held at a location accessible to physically handicapped people. If it's requested by that person, the person is entitled to be at the meeting. So there were some changes made to the committee section in 617, chapter 617, done last year. In accordance, oh my goodness, 2 years ago, we're in 2022 now. Pursuant to this particular statute, unless the articles or bylaws provide otherwise, the board is entitled to create 2 types of committees. There are board committees, and the board committees have the authority to act on behalf of the board. Because they have this authority, the committee has to be made up of a majority of directors. There are a couple of exceptions to this rule. If the committee is created by the board or is otherwise authorized by the Articles of Incorporation, does not have to be a majority of the directors. And the committee relates the election, nomination, qualification, or credentials of directors, or is involved in the process of electing directors. This might be like your nominating committee, if your bylaws provide for that. The other type of committee is advisory committee. This is most often the types of committees that are created by boards. They just provide recommendations. They don't act on behalf of the board or exercise any powers or authority of the board. Again, they just make recommendations to the board, the officers, and the members. This could be like your landscaping committee or a social committee, what have you. Exceptions to this statute are made for certain types of committees. And on the HOA context, it's going to be your finding and use right suspension committee. We'll talk more about that later. Your architectural committee, again, something we'll touch on later. And the organizing committee, which is established under the statute for covenant revitalization. We will talk about the Marketable Record Title Act briefly later, but that is part of the covenant revitalization, or the reason why associations may have to undergo covenant revitalization is because of the effects of the Marketable Record Title Act. So what do a golem and a board workshop have in common? If you, like me, are not of the Jewish faith, you don't know what a golem is. But they are both mythical creations. The mythical golem is summoned by observant Jews as a protector and guardian, and the workshop is used as a mythical tool to get around requiring noticing of board or committee meetings. If you have a quorum of your board getting together and conducting business of the association, that's a meeting. It needs to be noticed. No way around that. And this is exactly what I was about to explain. When does a board meeting happen between members? You can have a quorum of your board at dinner. That's not a problem. It's when you have a quorum of your board together conducting business of the association that is going to be considered a board meeting that must be noticed. So now you're on the board, you realize, man, I'm not getting paid to do this. I have people yelling at me all the time. I need to get off this board. Well, there are 6 ways to get off the board. One of them is really a suspension, but you can be recalled, which nobody wants to go through that. But we'll talk about that toward the very end of this lecture. Failure to satisfy that certification requirement. Again, that's a temporary suspension until you actually satisfy that certification requirement. Criminal charge, felony or theft, embezzlement offense involving the association funds or property, receipt of that excessive gift, you can resign in writing, or becoming more than 90 days delinquent in the payment of any monetary obligation to the association. All things that we touched on earlier in the presentation. Now, this particular section is kind of just miscellaneous topics that we felt were important to include, but didn't really have enough information about each to have a separate section. So it's just a melange of things that you guys should know. When you're keeping your minutes, all meetings should have minutes taken They don't have to be verbatim records. You don't have to say, Johnny said this and provide a quote of what Johnny said, and then Anita said this and provide a quote of what Anita said. Minutes of all meetings of the members of the association and the board of directors have to be maintained in written form or another form that can be converted into written form within a reasonable time. And when it comes to board meetings, a vote or abstention from voting on each matter for each director has to be set forth in your minutes. Right of access to parcels. The governing documents may grant the association a right to access an individual parcel in emergency circumstances or for the purposes of undertaking an owner's maintenance obligation on the lot in the event the owner fails to do so. This is something that's going to be completely governed by your governing documents, more likely than not your declaration. So you're going to want to have someone take a look at your declaration to figure that out if there is a need to get onto someone's lot. Material alterations and improvements. What is a material alteration? Recall that I said condominium law oftentimes bleeds over into HOA law. This is one of those instances. A leading condominium case defined material alteration to mean to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. Yeah, it's a long definition, but in the condominium context, it's pretty much any change that you're making that is a visible change or a change in use. Those are going to be considered material alterations. Chapter 720, again, does not require membership approval for material alterations or addition to the common areas or the association property. However, your governing documents might have some type of requirement, be it a blanket membership approval requirement for every material alteration or addition, or a dollar threshold. Let's say any material alteration costing in excess of $50,000 requires the approval of a majority of a quorum of the membership. Something like that might be required. Sometimes too, I've found that bylaws will have like an expenditure approval requirement. So you're going to want to check out your bylaws too when you're spending money on certain capital improvements, because there might be some language hiding in there. So amending the governing documents, I think we actually have a class of this coming up at an expo on February 1st. If my memory serves, but
correct.
Okay. Thank you.
At the
Power for Oz
convention center, yeah, the convention center in Okeechobee.
Yeah, so I think Allison Hertz is teaching that class, and correct. Then Peter Mullengarden is doing a legal update in the afternoon. So if you haven't signed up for that, go ahead and sign up. Those will be really good classes for you guys to check out. But briefly, when discussing amending the governing documents, unless otherwise provided in the governing documents or law, any governing document can be amended by the affirmative vote of 2/3 of the voting interest of the association. This is a new requirement. That's why it's in blue. That's why you see the asterisks. Amendments to the articles of incorporation or the bylaws, which affect or impose a quorum or approval requirement, voting requirement greater than the vote that's required or the quorum requirement in the existing documents, then you don't have to get that greater requirement. You only have to get the requirement for actually amending the documents. And sometimes, like I was talking about, that capital improvements bylaw provision that's hanging out in there. Let's say it says you need 80% approval to have a capital improvement expenditure over $100,000. But the bylaws can be amended at a 2/3 vote. Well, this particular statute section has clarified that you only need that 2/3 vote if you're going to change that 80% requirement. There is a new, maybe a couple years ago, format requirement. They copied this over from condominium law. You have to prepare your amendments with strikeout of the deleted language and underlining of the new language. If doing that process actually hinders the review of the amendment that's being proposed, you just put everything out in clean and you put in the little disclosure that's provided by statute that says substantial rewording, see governing documents for current text. That's what we always do if we're doing like amended or restated governing documents, because those documents are cumbersome, and providing all your members with a red line can be very confusing for them and costly for the association. This particular statute of 720 addresses the process of amending the governing documents when mortgagee consent requirement, there's a mortgagee consent requirement for amendments, and it applies to mortgages recorded after July 1st, 2013. Basically, you send a notice. If after 60 days there's no response, the lender is deemed to have consented to the amendment. And developers usually have the unilateral right to amend the declaration during developer control. However, there is an exception to that. They cannot amend if the amendment would alter the general plan or scheme of the development. An amendment to the governing documents to a governing document is effective when recording the public records of the county in which the community is located. And within 30 days of recording an amendment to the governing documents, you have to provide a copy of that recorded amendment. However, you don't have to provide a copy, but you can provide a notice if the amendment was sent to the membership before, was not changed at the vote or before the vote of the members, and the notice only has to include the official record book and page number, and a little disclosure that says you can get a copy of this amendment if you make a request to the association. If they make their request, you treat it as if it is any other official record request, and you provide it within that 10-day time. So this is brand new, this leasing restriction for amendments regarding rentals. There's something similar to it in the Condominium Act, although this has more exceptions to it. Let's just dive right in. Any governing document or amendment to a governing document enacted after July 1st of 2021 that prohibits or regulates rental agreements applies only to, 1, an owner who acquires title to a parcel after the effective date of the governing document or amendment, or an owner who consents individually or through a representative to the governing document or an amendment. There are certain exceptions to this application issue. The association can amend its governing documents to prohibit or regulate rental agreements for a term of less than 6 months, and can prohibit the rental of a parcel for more than 3 times in a calendar year. And these amendments will apply to everyone, notwithstanding what I just said above about it, applying only after purchase, after the effective date, or to those owners who consent to it. These rental restriction requirements, amendment restrictions, don't apply to associations with 15 or fewer owners. And there are certain change of ownership caveats that were put in there for business entities or affiliated entities. Under the rental amendment restrictions, a change of ownership does not occur when beneficial ownership of the parcel does not change, when an heir becomes an owner, when an owner remains title to an affiliated entity. And here's a little bit of a description of what constitutes an affiliated entity. And once that affiliated entity obtains title, they have to provide the association with a document certifying that that particular affiliated entity exclusion applies to that entity. A change of ownership does occur with respect to an owner that is a business entity when every person that owned an interest in the real property at the time of the enactment of the amendment or rule conveys their interest in the real property to an unaffiliated entity. So there was probably some strong lobby by LLCs or different rental companies that purchase homes in mass. Rules and regulations, a little bit of a change here. Couple years ago, maybe a few years ago, the Florida statutes were changed, were amended to add rules and regulations to the definition of the term governing documents. While this was all well and good, it kind of created an issue about amending and recording amendments to the rules and regulations. Remember, we spoke about it before. The statute refers to that amendment and recording requirement generally to governing documents. And once they added rules and regulations, which are usually not membership approved or recorded, create a little bit of havoc there. But they have since removed the rules and regulations from that governing document definition. Generally, rules and regulations, they can be adopted by the board. You're going to want to look at your governing documents to see if there's any membership approval requirement or if there's any particular process that has to be followed. Sometimes either the declaration or sometimes the articles too, but the bylaws may have like a notice requirement, mailing it out in a such and such number of days before it can become effective type of issue. We already talked about that. Okay, so written notice of any meeting at which the board will consider the adoption or amendment of any rule regarding parcel use has to be mailed, delivered, or electronically transmitted to all owners and posted conspicuously on the community property at least 14 days prior to the meeting. Remember, we spoke about that earlier. This is just bringing that back. Other rules, they're going to be subject to the normal 48-hour board meeting adoption requirement. Just know, again, look at your governing documents and see what other requirements might be in there for approval. Here we go, MARTA, Marketable Record Title Act. This can confuse a lot of people and even some attorneys about how the Marketable Record Title Act gets applied. I'm going to try to simplify it for you guys. Under MARTA, interest in land, which would include a declaration of covenants, they begin to expire on a lot-by-lot basis 30 years after the initial recording. In our case, it's the initial recording of the declaration of covenants. There are certain exceptions that can apply. Very rarely do I ever see them. One exception would be that the declaration is cited by book and page in the plat, and the plat reference is in every single legal description. So every time that the property gets conveyed, it's kind of like re-upping the declaration as to that lot. That might be an exception, or if the legal description itself refers to the declaration, but most times that exception is not going to be there. When you have the plat, you usually have the plat well before you have your declaration recorded. So notwithstanding that these exceptions exist, more often than not, you're going to be subject to MARTA. And when that 30-year clock starts coming to an end, you want to be sure that your board undergoes covenant preservation. We mentioned revitalization before. You don't want to have to undergo revitalization. It's much more an intensive process, much more expensive, requires membership approval, requires the approval of the Department of Economic Opportunity up in Tallahassee. And a preservation can be done with just a board meeting, board vote, and filing of a document. There are three ways to do it. There's the written notice, which was the old way up until October 1st, 2018, when changes were done. Now they have a summary notice. There's basically a form that's set forth in the statute, and the board approves it and it gets recorded. So simple to do. And the other is to do an amendment to the declaration. We often tell our clients, listen, you can do an amendment, but that's going to require membership approval. And a lot of times, unfortunately, a membership tends to be pretty apathetic. So doing the board action either by the summary notice or by the written notice, we often favor the summary notice because it's so simple, is a much safer route to go. Oops. Here we go. Okay, so let's talk about MARTA. Again, back when they added in those options for covenant preservation, they added the requirement at the first board meeting after the election, which is other than the organizational meeting. The board has to discuss the desirability of filing notices to preserve the covenants or restrictions of the community to protect it from extinguishment under MARTA. So it is very important to actually have this done so you don't have to undergo covenant revitalization. Service of process, a gated community has to allow a process server into the community to actually serve someone. Community association management. When do we need a licensed manager? So performing community association management means doing any of these skills: controlling, dispersing funds of the association, preparing budgets, assisting the noticing or conduct of community association meetings, day-to-day services for the operation of the association and the community. When it's done for remuneration, and when the association or associations served contain more than 50 units or have an annual budget or budgets in excess of $100,000. Now, someone who performs clerical functions does not have to be licensed when they have the direct supervision and control of a licensed manager. Managers do have certain standards that they have to live by. Community association manager and their management firm have to discharge their duties loyally, skillfully, diligently, honestly, fairly, in good faith, with care and full disclosure of the community association, accounting for all funds and not charging unreasonable or excessive fees. That having been said, they can provide an indemnification in their management agreement for ordinary negligence. However, notwithstanding the indemnification, it cannot cover any act or omission that violates criminal law, derives an improper personal benefit, either directly or indirectly, is grossly negligent, is reckless, in bad faith, is with malicious purpose, or is in a manner exhibiting wanton and willful disregard of human rights, safety, or property. Those cannot be covered under your indemnification in your management contract. Construction defect warranties. This particular slide lays out a history of how we got to where we are, but basically those off-site improvements like your drainage, roads, retention, piping, things that support your home, you have an implied warranty that extends to those particular facilities. And that's was established by the courts. Emergency powers. Okay, so we had emergency powers introduced a number of years ago, and this year they were expanded to include situations such as the COVID-19 pandemic. A homeowner association can perform several functions in the event of a state of emergency, unless, again, look at your governing documents and see what they say. These powers were expanded, again, to cover situations such as COVID-19. These powers include designating assistant officers, canceling or rescheduling association meetings. The meetings can be conducted by telephone, real-time video conferencing, or similar real-time electronic video communication like this Zoom. And notice of decisions can also be, notice of decisions can be made in the most practical manner as possible. Some other powers under here, mitigating further damage has been added to include mitigating injury or contagions, like sanitizing the common property, again, in response to COVID-19. Implementing disaster plans, and these plans can be implemented before, during, or following the event for the state of emergency is declared. Shutting down or off elevators, electricity, water, sewer, security systems, or air conditioners. And determining if the property or any portion of the property is unavailable for entry or occupancy at the advice of emergency management officials or licensed professionals hired by the board. There is another avenue for this advice. It's the public health officials, licensed professionals available to the board. And this extends to decisions as to whether any portion of the property can be safely inhabited, accessed, or occupied, subject to certain exclusions. Now, these are the exclusions. So you cannot prohibit owners, notwithstanding the emergency powers, you cannot prohibit owners, tenants, guests, agents, or invitees from accessing the common areas and facilities for the purpose of ingress and egress to and from the parcel when it's necessary in connection with the sale, lease, or other transfer of a parcel, or the habitability of the parcel for the health and safety of the person, unless the government order for or determination or the public health directive from the CDC has been issued prohibiting such access to the parcel. Any such access is subject to reasonable restrictions adopted by the association. When we were discussing this particular change and that portion about governmental orders from the CDC and reasonable restrictions adopted by the association, the way that the statute is structured, it tacks it on to this habitability, but we think it really should apply to both instances, but that's just not the way the statute was actually laid out. In order to exercise these emergency powers, the board may, without a vote, levy special assessments, borrow money, use the association's assets as collateral. There are a lot of freedoms that are or abilities, I should say, abilities and powers in this particular statute that the board can exercise. These powers are only available to the board for a period of time that is reasonably necessary to mitigate further damage and to make repairs and to protect the health, safety, and welfare of the association and its residents. Driver licenses, this is going to be important for those associations that have a gate or like a manned gate. It's unlawful for private entities to swipe driver licenses unless they have the consent of the individual whose license is being swiped, except when required for paying for goods and services with a method other than cash to verify age when providing age restricted, like if you have alcohol services on your property, to prevent fraud or other criminal activity in certain financial transactions. However, if the association informs the person what information will be collected and for what purpose, and the person consents, you can swipe the driver license. You can also take on the information manually from the driver license. Budget, special assessments, and reserves. Notice and adoption of the budget. This is quite different from a condominium association. So for those of you who wanted the condo class, you really need to hone in on what the condo requirements are, because they're very different than the HOA. Once the board has prepared and the proposed budget is typically adopted by the board, the governing documents need to be reviewed for any specific requirements. Sometimes there's like a 30-day requirement and the requirement to provide a copy of the budget before it's adopted. Let's see here. The Florida statute does not contain additional notice or agenda requirements. There is that one requirement to include the disclosure in the meeting that assessments will be considered and the nature of the assessment. If it's adopted by the board under law, it's that normal 48-hour. Just remember, non-emergency special assessments require a 14-day notice. So if it's adopted by the board, there's nothing special in your governing documents about budget adoption meetings. It's that 48-hour notice. Just know, a reminder, it was a non-emergency special assessment that you're adopting. It wouldn't be in your budget, but just know that it will require that 14-day notice in a manner similar to a membership meeting with the posting requirement. Before budget adoption, unless the documents require the board to provide a copy of the budget before it's adopted, there's no requirement by law, but you might want to, send it out anyway. Once the budget has been adopted, Florida statutes require the association provide each member with a copy of the budget or with a written notice providing that a copy of the budget is available upon request at no charge to the member. Again, similar to the notice of a recorded amendment, if the person actually makes the request, treat it like an official record request and provide the copy within 10 days after receipt of the written request. Each year, the association has to prepare a budget that sets forth the proposed expenditures of funds for the maintenance, management, and operation of the community and the association. It's adopted for a 12-month period and has to reflect the estimated revenues and expenses for the year, as well as the estimated surplus or deficit as of the end of the current year. You might as well use last year's actual expenses to plan for next year's budget. And monies in the operating section of the budget are not restricted to any particular purpose. So the board can use money allocated to one operating line item for other purposes as authorized by the governing documents. There are two main sections of your budget. You have your operating and your reserves. If you have any reserves, and we'll talk more about reserves in a bit. The budget for each association has to state the estimated common operating expenses on an annual basis, disclose the beginning and ending dates of the budget period. Again, it's that 12 months. And usually your fiscal year is going to be your calendar year. Show the total assessment to be paid by each parcel on a monthly basis or whatever your intervals are, maybe they're quarterly. Disclose separately all fees or charges paid by the association for recreational amenities, if you have that, and include reserves if you have reserves. And we'll talk more about that in a bit, like I said. Here are some examples of different operating expenses: administration, management fees, maintenance, insurance, professional fees. Those would all be considered your operating expenses for your day-to-day expenses of the association. Reserves. So deferred maintenance means any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of an asset. And a capital expenditure is any expenditure of funds for the purchase or replacement of an asset whose useful life is greater than 1 year, or repair to an asset that will extend the useful life of that asset for a period greater than 1 year. These are some examples of what might be covered by reserves. So there was a change, there were actually several changes by the 2021 Florida legislature to reserves for developer and under developer control. While a developer is in control of a homeowners association, the developer may, but is not required to, include reserves in the budget. If the developer includes reserves in the budget, the developer can determine the amount of reserves included. However, the developer is not obligated to contribute to the reserves during deficit funding. So if they're funding the common expenses by the deficit, meaning the difference between the actual expenses of the association versus the assessments they're receiving from other owners, from third-party owners, if they're paying that deficit, they're not going to be responsible for contributions to the reserves. The declaration of covenants, articles, or bylaws may not obligate the developer, may or may not obligate the developer to create reserves. But how do the developer reserves get funded? So this question is here because it's really not quite clear pursuant to the statute. And if you have developer created reserves, I would say talk to your attorney, talk to your accounting expert as to what your funding requirements are for those particular reserves. It used to be very clear in the Florida statutes that there were 2 ways to create statutorily protected reserves, meaning reserves that have to be funded pursuant to statute and can be waived or reduced or terminated pursuant to statute. But there's some confusion and things that will need to be clarified by legislature as far as, okay, well, what happens to these developer created reserves once turnover happens? How does it get funded? Does it have to be fully funded? So these are all very good questions that I don't have very good answers to at the moment. And I've talked about it with colleagues up here, and there's just no clarity, and there needs to be some provided by statute. Membership created reserves. These are reserves created by the affirmative vote of a majority of the total voting interest of the association. The approval action has to state the reserve accounts and must be provided for in the budget and must designate the components for which the reserve accounts are established. Once they've been approved, the board has to include the reserve accounts in the next annual budget. And the statutory reserve accounts have to be funded, maintained, or waived or reduced in the manner provided by statute. Reserves created any other way are really discretionary. They're not subject to the calculations and restrictions on the use of such funds set forth in the statute. Computing reserves, there is a method for computing reserves set forth in the statute. It's based on the estimated remaining useful life and estimated replacement cost or deferred maintenance expense for each reserve item. They can be adjusted annually depending on changes in estimates of costs or the useful life of a reserve item. You can pool, we'll talk about pools later. You can get, funding formulas for statutory reserves have to be based on a separate analysis of each required asset or the pooled analysis. We'll talk about pooling at the next slide. Unless the association maintains a pooled account for the reserves, you have to include a reserve account for capital expenditures and deferred maintenance for replacement as separate line items with the following disclosures: total estimated useful life of the asset, estimated remaining useful life, estimated replacement costs or deferred maintenance expense, and estimated fund balance as of the beginning of the period for which the budget will be in effect. Using reserves for other purposes. So let's say you have a reserve that's been set for your pool and you want to use the monies for resurfacing roads. Unlike operating funds, reserve funds and any interest accruing on those funds remain in the reserve account and can only be used for authorized reserve expenditures unless their use for another purpose is approved in advance by a majority vote of the members at a meeting at which a quorum is present or written consent if authorized. Pooling your reserves, the association can establish a pooled reserve account instead of or in addition to individual, those straight line item reserve accounts. If an association establishes a pool reserve account for 2 or more reserve items, funds can be drawn from the account only to pay for those particular items. Difference between individual and pooled reserve is really how the funding is calculated. Usually a pooled account will lower the reserve funding requirements. So your assessments may be a little bit lower because it has to do with timing and when you need to pull the money from the pool. You can waive or partially fund, i.e. reduce the funding for reserves. After 1 or more reserve accounts are created pursuant to the statute, the proposed budget has to include those and has to provide them for as fully funded unless a majority of the voting interest present at a meeting of the association's members, at which a quorum is present, vote to waive or reduce the funding of reserves. That vote is only applicable for the budget year that it was taken. And whether or not you actually want to waive or reduce reserves is really left to the board. This is not something that you have to do pursuant to law. Reserve accounts created by statute can be terminated upon the vote of a majority of the total voting interest of the association. Once they've been terminated, they need to be removed from the budget. Special assessments. Now, special assessment is assessment levied against an owner other than the regular assessment. Makes sense. You might call your regular assessments general assessments or maintenance assessments. Unless the bylaws provide otherwise, again, you need that 14-day notice for non-emergency special assessments. Has to be mailed, delivered, or electronically transmitted to the members and posted conspicuously in the community property. Has to include a statement that a special assessment will be considered and the nature of the assessment, and should identify the estimated cost of the assessment. Once it's been adopted, you should be sending out a notice and providing the owners with a reasonable time to actually make the payment for the special assessment. If a special assessment that's not paid by an owner can be collected in the same manner as any other assessment, including through lien and foreclosure process. Now, if a member vote is required, again, you need to be reviewing the governing documents, having your attorney review the governing documents to provide you with an opinion as to whether or not this approval is required for special assessments. And if that approval cannot be attained, what can you do? Well, you could, depending on what the expense is for, you could amend your annual budget. You could roll it into next year's annual budget. And there are certain exceptions that might apply, like a necessary maintenance exception type deal. Financial reporting. Each year, the board has to prepare and complete or go to its CPA for the preparation and completion of a financial report. Has within 90 days after the end of the fiscal year. That's when you need to go and actually seek that financial report. Also look in your bylaws. There might be a different date in your bylaws. Within 21 days after the financial report is available, but not later than 120 days after the end of the fiscal year, the board then must provide a copy of the financial report to each member, or again, can provide a notice that the copy is available at no charge and upon the request of the owner. There are differing levels of financial reporting that's required. Unless the governing documents set forth the requirement for an audit, it's based upon your total annual revenue. 150,000 or more, but less than 300,000, you're going to prepare compiled financial statements. If you have at least 300,000, but less than 500,000, you have reviewed financial statements. 500,000 or more, you need audited financial statements, and less than 150,000, you prepare a report of cash receipts and expenditures. You can change the level of reporting. If the board desires to raise the level of financial reporting, you can increase it without a membership approval unless the governing documents will require otherwise. And if a majority of the total voting interests approve raising the level of the financial reporting, the board has to do so, can adopt a special assessment to charge for whatever difference in costs may be incurred to obtain that audited report. If 20% of the owners petition the board to increase the level of the financial reporting from that required by statute for that fiscal year, the board has to notice and hold a membership meeting within 30 days of receipt of the petition. And the level of financial reporting may be reduced from the statutory required level only if approved by the majority of the voting interests present at a duly called membership meeting. So required reserve disclosures. Now this changed a little bit. Again, remember I told you that the reserves issue for developers changed slightly. Well, this was another change they made because of that whole developer reserve issue. If the budget does not include reserve accounts created by the membership, or the declaration, articles, or bylaws do not obligate the developer to create reserves, the association is responsible for the repair and maintenance of capital improvements that could result in a special assessment if there are no reserves. Each financial report for the preceding fiscal year has to contain a statutorily provided statement warning of the consequences conspicuous type. And these are the particular warnings. Again, they were slightly revised. And these are, again, required by statute and set forth in the statute. There are a couple of other governmental filings that the association needs to be aware of. Your annual report, you have to file that, you guessed it, annually with the Division of Corporations. It basically says, asks you for who your officers and directors are, registered agents, stuff like that. Very easy to file online. And your annual income tax, just because you're a not-for-profit doesn't mean that you're not going to be subject to taxes. Particularly, if you're creating reserves that are discretionary, you may want to talk to your tax expert about any potential tax consequences that may be incurred by that. A little bit about contracts and bids. Contracts have to be in writing if they cannot be fully performed within 1 year for the purchase or lease of materials or equipment, and if it's a service. All written contracts entered into by the association for operation, maintenance, management of the association or the property serving owners should specify the obligations of the party contracting to provide maintenance or management services, the cost, the frequency, minimum number of personnel. These are things that should be included in your contracts and really, are your business terms. If the aggregate costs of the contract is more than 10% of the total annual budget, including reserves, the association has to obtain competitive bids for materials, equipment, or services. You don't have to accept the lowest bid. You're not required to obtain competitive bids for products and services in emergency circumstances, or if the business entity is the only source of that particular service or item within the county serving the association. And contracts executed before October 1st, 2004, and any renewal of those contracts are not subject to the competitive bid requirements. That's likely because that's when this particular statute came into effect. Certain contracts are exempt from the bidding requirements, such as contracts for employees of the association, services of an attorney, accountant, architect, community association manager. However, you need these contracts in writing, and a contract with a manager, if made by competitive bid, although not required, can be made for up to 3 years. If a contract was awarded under the competitive bid procedures, any renewal of that contract is not subject to competitive bid requirements if it provides for 30-day cancellation. The associations whose declarations or bylaw provide for competitive bidding can provide for competitive bidding, but the provisions cannot be less restrictive than the statute. So statute says you need competitive bidding for a 10% contract. You could provide in your governing documents, your declaration or your bylaws, a 5% bidding requirement, but you can't do a 15% because that's less restrictive. Okay, so a little bit about communication services. Contracts for bulk internet, cable, what have you, are deemed an operating expense and can be allocated on a per parcel basis rather than a percentage basis, even if the governing documents provide for other than equal sharing of operating expenses. You can change the allocation by a majority of the voting interest present at a regular or special meeting of the association. And any contract for these bulk services entered into by the board can be canceled by a majority of the voting interests present at the next regular or special meeting of the association. And if it's not canceled, then it's deemed ratified. There are certain circumstances under which a bulk contract won't apply to a particular parcel. And that's where there's a hearing impaired or legally blind person who does not occupy the lot for the parcel with a non-hearing or sighted person, parcel owner who receives supplemental social security income, or they're on food assistance administered by the DCFS. They can discontinue services without incurring any disconnect fees, and they're not required to pay any operating expenses related to those services. They will just get absorbed by the remaining members, if any. Other providers. So let's say the association has hot wire and somebody wants to have a dish. A resident of any parcel, whether a tenant or a parcel owner, may not be denied access to available franchise licensed or certified cable or video service providers if the resident pays that provider directly. And a resident or cable or video service provider cannot be required to pay anything of value in order to obtain or provide such service, except for those charges which are normally paid for services, similar services outside of that community. So a little bit about use right suspensions, voting suspensions, and fining. This has changed slightly for voting suspensions because of the case law that came down. Authority to fine and impose use right suspensions for everything but failing to pay monetary obligations. So this is going to be enforcement authority if there's a violation of the governing documents, like parking your car where it shouldn't be parked, or leaving your trash out, what have you. A fine or use right suspension may not be imposed unless the board first levies the fine or use right suspension and provides that violator with a 14-day notice and opportunity to be heard before a committee. The hearing has to be held before a committee of at least 3 members appointed by the board. Those members cannot be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. They want to make sure that it is an impartial committee. And the role of the committee is limited to determining whether to confirm or reject the fine or use right suspension that's levied by the board. If the committee does not confirm the fine or suspension, it cannot be imposed. If the committee says, oh, well, I think a 30-day suspension is a little harsh, let's make it a 15-day, that's not considered an approval or confirmation of the suspension. That would be considered a rejection of that suspension. A fine cannot exceed $100 per violation unless otherwise provided in the governing documents. And the fine can be levied on the basis of each day of a continuing violation, but cannot exceed $1,000 in the aggregate unless provided in the governing documents. So look at your governing documents, see what they provide as far as how much a fine can be and how much a fine can accrue to. A fine of $1,000 or more can become a lien against the parcel and collected through the lien foreclosure process if authorized in the declaration, and the fine payment is due 5 days after the date of the committee meeting at which the fine is approved. That was added in a couple years ago. Use right suspensions. So we know that we can have fines and use right suspensions for violations of the governing documents, but we also have use right suspensions for failing to pay monetary obligations due to the association greater than 90 days. It's not on the 90th day, it's on the 91st day. Through board action, an association may suspend an owner's right to use the common area facilities if the owner is more than 90 days delinquent and any monetary obligation due to the association. It's done by board action at a properly noticed board meeting. There may be a way you can go ahead and do that globally if done properly. And in order for the suspension to take effect, written notice of the suspension has to be mailed or hand delivered to the owner, and if applicable, to the occupant, licensee, or invitee. While the association has the authority to suspend use rights, the suspension does not apply to the portion of the common areas used to provide access to the parcel or utility services to the parcel, and it cannot prohibit vehicular and pedestrian access to and from the parcel, including the right to park. Now, this was changed a couple of years ago from impair to prohibit. So for those associations that have a gated community, perhaps now the option is available to you to force the owner to go through the guest side as opposed to going through the quick pass owner side, because it's not a prohibition. It was an impairment, but now it is not a prohibition. A suspension applies to a member, and when appropriate, the member's tenants, guests, or invitees even if the delinquency or failure that resulted in the suspension was from less than all of the parcels owned by that owner. So voting suspensions, like I mentioned earlier, there was a case recently. It was a condominium case, De Soleil. And in that case, the association wanted to suspend voting rights of certain members for failing to pay monetary obligations greater than 90 days based upon the statute. And they did so. And the members challenged. Well, turns out that the case, which I do believe was a third DCA case, said, no, you can't do that because there's no Kaufman language and the declaration does not provide the suspension of voting rights as a remedy for delinquency. So this particular case has really called into question the association's authority to suspend voting rights. Again, this is a condominium case, but oftentimes condominium decisions bleed into HOA law. It's just a fact. So you're going to want to be very careful and talk to your attorney about your ability to suspend voting rights. Again, voting right suspensions are only available for delinquencies greater than 90 days, similar to use right suspensions for delinquencies. Board action, you have to send a notice, and the suspension is effective for as long as they're delinquent. And this particular slide just discusses how it gets done similar to the use right suspension. If you're suspending voting rights, you want to be careful because sometimes you may be taking voting rights away from those people who would be in support. But whatever you decide to do, you have to do it consistently. Covenant enforceability and dispute resolution. The association is charged with the responsibility to uniformly enforce the governing documents. There are some examples of what those restrictions might be. If you're 55 and older, pet restrictions, sales and leasing, what have you. A community association through board action can extinguish discriminatory restriction that was added in this past legislation. The association can institute, maintain, settle, or appeal actions or hearings in the name of the association on behalf of all owners concerning matters of common interest to the members. Here are some examples of that. Representations of the developer pertaining to any existing or proposed commonly used facility, common areas, roof structure. Just be aware that there is this $100,000 rule. Before the association can commence litigation against any party where there are amounts in controversy in excess of $100,000, the association has to obtain the approval of a majority of the voting interests at a membership meeting at which a quorum has been attained. But disputes between an association and an owner, there are certain disputes that are subject to pre-suit mediation. The process is set forth in the statute. And there are certain disputes that are not subject to pre-suit mediation, and you can go right to court or the Division of Florida Condominiums, Timeshares, and Mobile Homes when it comes to recall and election disputes. So some of those disputes that are subject to pre-suit mediation are disputes regarding use of or changes to the parcel of the common areas, amendments to the association's documents, meetings of the board, meetings of the committees, membership meetings, not including election meetings, access to the official records and covenant enforcement. Anything really having to do with money, fines, fees, landlord-tenant issues, breaches of fiduciary duty, those things you need to go to court for. And again, recall and election disputes, you can go to arbitration with the division. Pre-suit mediation procedure, I said before, is set forth in the statute. Basically, what happens is you send out an offer to participate in pre-suit mediation. The responding party has 20 days to respond. In that offer, you have to list 5 different mediators, provide some information, and the respondent selects one of those people. The parties are required to share the cost of the pre-suit mediation equally, including the mediator's fee, And sometimes the mediator requires that the fee be paid in advance, notwithstanding, however long it might take. Usually they have some type of time minimum, like 4 hours, what have you. An impasse entitles the aggrieved party to proceed in court against the responding party without further notice and to seek an award of attorney's fees and costs associated with the mediation. In any of these instances, the party fails to respond to the written offer within that 20-day period. They failed to select one of the mediators provided. They failed to make payment to the mediator, or they failed to appear at the scheduled mediation. At that point, then you can go straight to court. Attorney's fees are awarded only if authorized by contract or statute. That's just the general rule. In a mediation, if there's an impasse, that person who created the impasse is not able to receive attorney's fees and costs in subsequent litigation relating to dispute. If a dispute is not resolved at pre-suit mediation, the prevailing party in any subsequent arbitration or litigation proceeding is entitled to seek recovery of all their costs and attorney's fees incurred in that mediation. And if the dispute was settled at pre-suit mediation, but an action seeking enforcement of the settlement agreement coming out of mediation, the prevailing party in that subsequent arbitration or litigation is entitled to seek recovery of their attorney's fees and costs incurred in that pre-suit mediation process. Architectural standards, just a little bit here about that statute. I was talking earlier that we would come back to architectural committees, and here we are. The authority of the association or any architectural construction or improvement or similar committee, again, your ARC, ACC, ARB, whatever, their authority to review and approve plans and specifications for the location, size, type, or appearance of any improvement on a parcel, or to enforce standards regarding the external appearance of any improvement, is permitted only to the extent that the authority is specifically stated or reasonably inferred as to those things, location, size, type, or appearance, in the declaration or other published guidelines and standards authorized by the declaration. If there are options for particular improvements, design, location, what have you, that are in the declaration or the published guidelines authorized by the declaration, the association or the committee cannot restrict the right of an owner from selecting from those options. Just know that the law favors the free use of property. So when it comes to the association or the architectural committee telling what an owner can or cannot do on their property, it's best you have some type of regulation for that particular item. The failure of the association to enforce its covenants, restrictions, rules, and regulations may lead to a waiver, affirmative defense by that particular owner. It's an equitable defense. The enforcement process. This basically lays out the preferred method of going about enforcing your governing documents. Send a letter, provide them with an opportunity to respond or to make right on whatever the violation is. When voluntary compliance is not achieved, then you can move it up to the next step, whether it be pre-suit mediation, litigation, doing findings, suspensions, what have you. Before, basically just send out notices, make the person aware, provide them with the opportunity to cure whatever the violation is, before going nuclear. Treat others the way you want to be treated. Official records. So what are official records? Basically, it's any written records of the association. All records have to be maintained for at least 7 years. There are certain records that can be held for less number of years. Like, again, your certificate coming out of this class is a 5-year. Bids, those can be kept for, have a 1-year limitation on them. But basically any written record of the association, that's going to be part of the association's official records. There's a list for you here. Recently added to this list were ballots, sign-in sheets, voting proxies, and other papers and electronic records relating to voting by owners. Those have to be maintained among the official records of the association for at least 1 year. And all affirmative acknowledgements made to this new statute have to be part of the official records. We'll talk more about this affirmative acknowledgement coming up. Certain records are not subject to the associate or to membership inspection and copying. These records are those protected by the attorney-client or work product privilege, medical records of owners or residents. Think about, if you receive medical records concerning an emotional support animal request, those would be protected from inspection and copying. Personnel records, information obtained in connection with the approval of a sale, lease, or other transfer of a parcel. A lot of times associations where they have the authority will do background checks, credit checks, that information, although part of the association's official records are not subject to inspection and copying. Any electronic security measure that's used by the association, personal identifying information, social security numbers, telephone number, email address. There are certain exceptions to this. It's the person's name, parcel designation, mailing address, property address. Those are accessible, and we'll talk more about member directories. Whoops. Coming up. There are a couple of items added to the non-accessible official records information the association obtains in a gated community in connection with guest visits to parcel owners or community residents. And again, those affirmative acknowledgements, which we'll talk about soon. This provides you with a little explanation of what is covered under the attorney-client privilege. Correspondence from the association's lawyer remains privileged unless the board votes to waive the privilege. The board has the attorney-client privilege. We as attorneys do not have the ability to waive that privilege. That rests with the board. Member directories. An association can print and distribute to its owners a directory containing the name, parcel address, and all telephone numbers of each owner. The owner can exclude his or her telephone number from the directory by requesting in writing to the association. The association is not going to be responsible for inadvertent disclosure of protected information if the information is included in an official record maintained by the association and is voluntarily provided by the owner and not requested by the association. An owner can also provide the written consent and disclosure of additional information. The association has to maintain an adequate number of copies of the recorded governing documents to ensure their availability to members and to prospective members. The official records have to be open for inspection and available for copying by members or their authorized agents at reasonable times within 45 miles of the community or within the county. Have to be made available within 10 business days after receipt of written request for access. If the request is sent by certified mail return receipt requested and the records are not produced or access is not provided to the records in that time, excuse me, it creates a rebuttable presumption that the association willfully failed to disclose those records. The association can have a copy of the official records available for inspection or copying in the community on an electronic platform via the internet, or can allow the records to be viewed on electronic format on a computer screen and printed upon request. The association is not required to go through all of its official records and cherry pick records that are being requested by an owner. You'd have to provide access to them. You don't have to do much more than that. The association may and should adopt reasonable rules governing the frequency, time, location, notice, records to be inspected, and manner of the inspection. However, the association cannot require an owner to show any proper purpose for the inspection, state any reason for the inspection, or limit an owner's right to inspect records to less than 1 8-hour business day per month. There are ways that you can impose a fee for doing the official records copying. If they bring something with them, like their phone, to take pictures of it, you can't charge for that. I've even seen people bring in like copiers. They can bring a copier if they want to, and there won't be any fee by the association for doing that. There are certain fee requirements that are set forth in the statute. You guys can look at that as your leisure, because I know we're running out of time and I want to get through some of these other topics. This is what I was talking about before, portable device, not charging a fee for that. If you don't timely provide access to the association's official records, meaning within that 10 business day after receipt of the written request, again, there's that rebuttable presumption that the association willfully failed to comply with the subsection. And the owner member can obtain damages. It's a minimum damages are $50 per day, up to 10 days, starting on the 11th business day. assessments and foreclosures. So this is a new requirement as of the 2021 legislature. If the association sends out an invoice for assessments or a statement of account, they have to be delivered to the owner by first class US mail or by email. There's a little definition of what a statement of account is because it is provided by statute. Before changing that delivery method, the association has to send out a notice to each owner at least 30 days before changing that method of mailing. And has that method, that notice has to be sent by first class US mail to the owner at their address as reflected in the official records. And if not the parcel, then to the parcel. And the owner has to affirmatively acknowledge electronically or in writing their understanding that the association will change its delivery method. This is that affirmative acknowledgement that was added to the official records section, and although is part of the official records, is not subject to inspection and copying. This is a new notice that's required in the collection process. So the next few slides will talk about the notice of intent to lien, and then the notice of intent to foreclose. The notice of intent to lien is a 45-day notice you have to provide to an owner before you can actually record a lien against their property. If they don't pay up within that 45 days, the association then can record the lien. After the association records the lien, they have to send a notice if they intend to foreclose, and that's also another 45-day notice. So they have built in at least a 90-day lead time and a couple of notices that are required before you can actually get to foreclosure. Well, the statute has now been amended to require an additional 30-day notice at the very beginning of the process, and it's called this notice of late assessment. There is a form that's set forth in the statute that you'll want to take a look at and use if you want to do collections on any of your membership. Again, it's a 30-day notice if they pay, they don't get assessed for attorney's fees. Again, look at that statute for the form. Has to be sent by first class US mail to the owner. And if that's not the parcel address, then also the parcel address, a rebuttable presumption that the association mailed the notice in accordance with the statute is established if the board member, officer, or agent of the association, whoever sent it, provides a sworn affidavit attesting to the mailing. Interest, assessments that are not paid, bear interest at the rate provided in the declaration of bylaws. If no rates provided, it is 18%. That's provided by statute. Administrative late fee not to exceed greater of $25 or 5% of the installment can be imposed if permitted by the declaration of the bylaws. Again, don't charge interest on interest or on late fees. Attorney's fees and costs, you can recoup those in collection. Application of payments received by the association get first applied to interest, then to late fees, then to attorney's fees, then to the actual delinquent assessment. And any restrictive endorsement that's put on that payment or any purported accord of satisfaction for receiving payment that is less than what is fully due, they're not operative. I briefly spoke about this earlier, so I'm just going to flip through it. It's that 45-day notice of intent to lien, then you record your lien, then that 45-day notice of intent to foreclose. You've probably heard the term safe harbor before when it comes to a first mortgagee who forecloses on a property within your community. The first mortgagee has to initially join the association in that foreclosure. And once they foreclose, the assessments are limited to the delinquent assessments having accrued on the property 12 months before acquisition of title, or 1% of the original mortgage debt, whichever is less. You're also going to want to look at your governing documents to see what your governing documents provide. Perhaps, there's a clean wipe of the slate. You're going to need to look at the governing documents for that. This slide is basically saying that if a sub-association forecloses on its lien and there are monies due to the master association, basically the master association delinquency gets wiped. Third-party bidder at a foreclosure property has joint and several liability for past due assessments. There is a caveat, and it's if the association owned the property prior to that if the association did an assessment lien foreclosure, obtained title, and then the lender foreclosed, you're not going to be able to collect for the assessments that accrued while the association owned the property. There are ways to accelerate a lender foreclosure. This is really for your collection attorney to know. This order to show cause. The importance of the order to show cause here is that it can only be used on non-owner occupied residences. Rent demands, if you have a property that is leased out and the owner becomes delinquent in their assessments, there is a way under statute to make demand on the tenant for rent to be remitted to the association. At times, the association can acquire title to an abandoned home through assessment foreclosure and lease it out. You can do it through a receivership. You pay the receiver through the whatever lease monies you receive. Insurance. The association is responsible for obtaining and maintaining adequate insurance to cover the common areas, facilities, property management. And association property that the association is responsible for maintaining, repairing, and replacing. The association should also have D&O coverage. Flood insurance is highly recommended. Fidelity bonds. So you have to have fidelity bonding or insurance coverage for all persons who control or disperse funds of the association. The bond has to cover maximum funds that will be in the custody of the association or its management agent at any one time. However, there is the ability for the membership to waive the requirement by a majority vote of the total voting interest present at the meeting, and it's only on an annual basis. Covered perils. This slide is basically saying, know what's on your insurance coverage. If it has a general reference to statute, that's not sufficient. Make sure that it is specific. I'm going to pass right over this so that we can get to, here we are, Federal Fair Housing Act. So a lot of times, people who are wanting to get their animal into a community will say that they have an ADA animal. Okay, that's fine and well, and they may very well have an ADA animal, meaning a service animal, but really the association is governed by the Fair Housing Act because the ADA applies to employment, government, public accommodations, whereas the Fair Housing Act applies to private housing, similar to our residential communities. Both prohibit discrimination based on disability. The Fair Housing Act has a lot more protections for other classes like race, religion, sex, color, familial status, and national origin. Both provide for accommodations to policies and physical facilities. Both provide for animals which assist the disabled. Handicap uses the term disabled. ADA uses the term disabled. FHA uses the term handicap. 6 1/2 dozen the other, they still have the same meaning. And they both may apply depending on the circumstances. But like I said, residential communities are going to be governed by the Fair Housing Act. ADA comes into play because of the service animal aspect. It's unlawful for a housing provider to ask about the nature or severity of a person's disability, or if an applicant who intends to own and or reside within the association's community has a disability, or if a person associated with that applicant has a disability. Assistance animals, they're not pets. So any pet regulation that you have is not going to be applicable to an assistance animal. An assistance animal is an animal that works, performs tasks, assists, and or provides therapeutic emotional support for individuals with disabilities. The FHA does not require an assistance animal to be individually trained or certified. So those pretty little certificates that you get from people wanting their assistance animal with them don't really have any relevance to the analysis because there's no certification that's required pursuant to the Fair Housing Act. While dogs are the most common type of assistance animal, there can be other types of assistance animals. And assistance animals perform many disability-related functions, guiding individuals who are blind and have low vision. You have your diabetes animals that can smell the sugar levels of your breath. Lots of different functions that these animals can perform. First, we need to figure out what type of animal is it. So we get a request and what do we do now? Okay, so what type of animal are they requesting? Are they requesting a service animal that would be covered by the ADA? Are they requesting a support animal? Now, the ADA does not recognize emotional support, comfort, well-being, and companionship as worker tasks that a service animal performs. So those animals are never going to be considered service animals under the ADA or actually under the FHA. Is the animal a dog? If it's a dog, then it could be a service animal. If it's not, well, then it could only fall under the category of a support animal, emotional support animal. Is the animal trained to do work or perform tasks for the benefit of an individual with a disability? If yes, then you have to let in the animal as a service animal. If no, it could still be a support animal. Is the animal required because of a disability? If yes, and the worker task is identified, then you have to grant the request and you cannot ask for further documentation. If not, then the animal is not a service animal, but can be a different type of assistance animal, meaning a support animal. This analysis was actually recently updated, which is why you saw the double asterisks on a couple of slides ago when HUD issued a new guidance back in January of 2020. So that's why we changed up the analysis, and that's why you saw those asterisks there. If an animal is not a service animal, it can still be entitled to access if it's considered a support animal. It does not have to be trained again, and they can provide emotional support. Doesn't have to be a dog, can be, you know, this cute little kitty or a little bunny rabbit. What can you ask? Well, if you need documentation to support the disability, meaning that it's not readily apparent, and you need documentation showing the disability related need, meaning that that is also not readily apparent, the association can ask for written opinion of a physician, psychiatrist, social worker, or other health professional which establishes that the applicant has a disability, which is most commonly defined as a physical or mental impairment that substantially limits one or more major life activities, and establishes that the support animal performs tasks or services for the benefit of the disabled person or provides emotional support that alleviates one or more of the identified symptoms or effects of that person's disability. There is a Florida version of it's the Civil Rights Act in Chapter 760. Basically conforms to the Federal Fair Housing Act. These issues are very much determined on a case-by-case basis. There is no black and white. So you really need to be looking at these issues singularly and not in creating a black line rule about things. There were some changes made to this statute in Chapter 760 regarding emotional support animals specifically. Take a look at those because some of it does have to do with out-of-state practitioners. And these are good and you can rely on them. However, just know that this is a state law and there are federal laws which cover this. So if push came to shove, federal typically wins over the state. Let's see, if a person requests to keep more than one emotional support animal, the housing provider can request information regarding the specific need for each animal. Just because they have a support animal or a service animal, i.e. assistance animal, doesn't mean that the health laws don't apply. So you can still require that the animal be inoculated and be licensed with the county, and that you can get information or require proof of that. This slide provides a little bit of a definition of what can be considered a disability. A lot of things, a lot of different conditions can be a disability if they substantially limit one or more major life activities. And the list of life activities is not overly inclusive. It could really be anything, as you see here: walking, seeing, hearing, speaking, breathing, learning, working. These are all considered major life activities. So I know I've just gone over my time. Just briefly, recall of directors. Directors can be recalled by a majority of the total voting interest, can be done in a membership meeting, can be done by written agreement. There were changes recently made by the 2021 legislature that allows a person, an owner or a board member aggrieved by whatever decision comes out of the board meeting to either certify or not certify the recall can now be taken to court instead of having to just go through division arbitration. And that's what you see here in blue. No petition will be accepted by the division if there are 60 or fewer days until the next election, or if it hasn't been more than 60 days since the election. So you kind of have that 60-day bookend from the election. You either need to challenge the election. After that 60-day challenge period ends, then you can recall. And if there are less than 60 days to the election, you just need to be patient and wait for the election. You can't do a recall at that point. So this particular section talks about turnover. If you are one of the few people who are on a developer controlled board, I'm not going to go through this particular section. You can read it on your own. It basically talks about the triggers for when turnover begins to occur. There's a trigger at 50% sold to ultimate third parties, where the members get to elect at least one person to the board. And then there's the trigger for when the turnover occurs, when majority control gets turned over to the members. And it discusses certain developer obligations after turnover, like providing the audit, providing the official records, names of the owners, what have you. So that is the end. I know it's a lot of information, and I do try to get through it all. My voice is destroyed.
That is a lot of
Thank you guys so
information.
much.
You did fantastically. That is a lot of information, and it's not easy when you're not live at a venue to have the interaction, a pause, to have a sip of water. This is so well done. We know this is not normal and not easy to do. So thank you. Excellent job, Danielle.
Thank you, guys.
Danielle and I will speak afterwards about getting some of these questions addressed in maybe like an after show where we record it and email it to everybody. So we're going to discuss that because there are a lot of questions in a limited amount of time. And we apologize we couldn't get to the questions that required an attorney's answer. I'm not an attorney. I was answering the ones that I was able to answer. So we'll try to do some of those on something that we record and send to everybody. We'll talk about that. But thank you for your patience and understanding with that. Just way too much in a short period of time.
I know.
And I had a few questions here that were asking me to go over the evaluation process one more time. So I'm going to do that right now. Danielle, I know you're swamped at the office. If you need to go, you can go ahead. But I'm going to go over this briefly with everybody, if that's okay.
Yeah, absolutely.
Okay.
Thank you guys very much. I know it is a lot of information. I know sometimes it can just be me like rattling off, but again, that is kind of the nature of the webinar. Thank you so much for joining me. I hope you guys are staying healthy and have a great weekend.